since you are on a time crunch, let's go ahead and get started. I'll start with you, Danny. You know, it seems like, and I'm taking the glasses off because this is straight lawyer talk here, that judges are starting to make a very direct connection between the posts on social media that the former president is engaging in and the response that he's getting from his followers, and seeing that as a real threat. I'm going to read for you a quote that came out of this hearing in D.C. this week. It says, one of the judges asked, why does the district court have to wait and see and wait for the threats to come rather than taking a reasonable action in advance? Do you think that judges are really starting to sort of dismiss the arguments that have been made by Donald Trump's defense team about some of his social media activity?
Never before has any court had the challenge of gagging a defendant like Donald Trump. Because, as you know, Charles, for the vast majority of criminal defendants, if they criticize the judge, if they criticize the prosecutor, nobody cares, because it's not even remotely political speech, and nobody, for the most part, is listening. Maybe they have a couple hundred followers on Twitter. Who cares? This has never happened before, where you have a political figure who is making the argument that everything he says, as ridiculous and offensive as it is political speech. And there's another layer of complexity, which is this. Do we curtail someone's First Amendment rights based on what other ill-advised, stupid people do in response to what that person says? Because when you look at his words alone, they may not incite riot, they may not be a call to action or a call to violence, but other misguided people will take it as such. So how do we deal with that constitutionally? Do we hold Donald Trump responsible for what those people do idiotically? And do we curtail his First Amendment rights? This is a rhetorical question. I don't know the answer, and I don't know that the courts know yet either. This has just never been dealt with before.
Anthony, speaking of social media and posts, you were on social media this past week, and you were talking about the notion that basically what Donald Trump is doing around these gag orders and how he's responding is an attempt to control the public narrative.
Right.
I tend to agree with you, and I've been saying that along with a lot of other people for a very long time. My question to you is, how successful do you think he is being with that ploy?
Yeah, he's been very successful. I will break it down. I'm not the lawyer, as both of you, so I'll speak,
listen, you're grandfathered in because of your time at DOJ, so it's all right.
So here, let me break it down. Trump is playing dirty. He knows full well that anytime he attacks these lawyers, these prosecutors, these judges and their staffs, he knows that many of his followers view these things as marching orders. And there's a pattern of it. I remember in September of 2020, he is asked specifically to condemn violent right-wing extremism. He demurs and he tells the Proud Boys, you know what he says? Stand back and stand by. In December of that year, he tells people, he summons them to Washington, D.C., and he tells them, come, we'll be wild. And then they show up on January 6th. And I went back and I read the transcript of his remarks. The word fight or fighting is mentioned 20 times in that transcript. He tells them to fight like hell. You know what they do? They go down to the Capitol and they fight like hell. And they only stop when he tells them to stop. So there is a clear correlation between what Donald Trump says and what his supporters do. And my hope is that the court recognizes that quickly, because people's lives are at stake here. And that is not hyperbole.
Now, I want to follow up with you. Yeah. You're the messaging guy. You're the communications guy. We're the lawyers. I think that a lot of people don't realize that for Donald Trump, in terms of him pushing the narrative, there is a space where it's heads I win, tails you lose, in terms of how he can control the narrative from purely a messaging standpoint. I'm talking about the technicality of it, not the quality of it or its substance. I'm talking about, the overall outcome that he seeks to advance. Is it a good idea?
So there are two things here. Number one, I think he has this two-track objective. He's trying to delay these cases for as long as he can. That's especially true with Judge Eileen Cannon, and we're going to talk about that, I hope, in a little bit. But the other thing, what he's trying to do is to change public opinion, to influence what happens inside the courtroom, to influence what happens inside the court of law. Remember, he really only needs one member of a jury in any of these cases to say not guilty. And so what is he trying to do? He's trying to intimidate witnesses. He's trying to poison the jury pool. That's his goal here. And I would say, just from my observation, both of these things, his political campaign and his legal woes, they're all intertwined here. And I think that's what he's trying to do.
Now, Danny, Anthony has told us we need to move on to Aileen Caney, so let's just do that.
Yep.
As attorneys, we are looking at this trial calendar, okay? And delays are not necessarily, unusual. It's something that happens. People are arguing that Aileen Cannon seems to be setting the stage to push this as close to or beyond election 2024. What's the likelihood that that happens?
Very likely. I've said that as to most of these cases, especially the state court cases, you can plan on 2025 for trial to start. When it comes to the Fulton County case, first witnesses in 2025. Save the tape. I've said it before. Don't save the tape, just in case I'm wrong, but save it so I can say it now. The point is that these cases are going to take a while. These are the most significant criminal trials in American history. And while the government, at least in the documents case in Florida and in the D.C. case, they may feel that they're ready to proceed for trial. Absolutely, the D.C. case is designed for speed. That will probably be the first one to go to trial. The documents case is complex. The government says they can proceed to trial sooner. Yeah, but as a defense attorney, the government is usually pretty ready by the time they indict the case. It's the defense that has to look through terabytes of documents and decide how to proceed, what kind of defense they want to put on. So I am a little sympathetic with the idea that this will take some time. But at the same time, federal court generally moves very quickly. I think the May 20 trial date in the documents case in Florida is probably not going to happen. In my experience, what federal judges do, because they have so much pressure to move cases along, they'll set a trial date that may not be realistic, and they leave it to the parties to make a motion and ask them to move it. That way, the judge has done his or her job, and the parties can fight over whether or not that's a good trial date. And believe me, they are going to fight about it because the government has made the case, and I think it's a credible one, that even though these are complex issues, the documents, there are different tiers of classified and more sensitive, less sensitive documents. They still think they can go to trial sooner rather than later. But the defense is going to make a lot of arguments, some of them reasonable, some of them stretches. That's our sworn duty. You know that, Charles, as defense attorneys. As long as we're zealously representing our client within the bounds of ethics, we are duty bound to try everything we can. And the reality is delay in this case, delay usually inures to the benefit of the defense, but never before in American history has delay inured to the benefit of a criminal defendant, like it will for Trump, because if this case is still pending, any of the federal cases, he'll simply appoint an attorney general who will dismiss it. If that doesn't work, he will try, may not be successful, will try to pardon himself.
But Anthony, I'm going to put you back in your former role really quickly. We haven't heard much from Jack Smith, understandably so, and we haven't heard much from Merrick Garland. The closer that these trials get pushed toward an election, would you advise either of them to say something publicly about the need to either hold off or the need to press the gas? And if so, which one?
Yeah, so I don't imagine them to say anything outside of the court of law. Listening to you talk about this is really interesting, because my takeaway is that Judge Aileen Cannon in this case, she feels like she's a referee who's trying to rig a game before it even starts. That's how I view this. But the fact of the matter is that the evidence in this documents case is so overwhelming. We're not talking about, George, something that a witness may or may not have overheard secondhand in a coffee shop. We're talking about here solid evidence, firsthand accounts from people who were in Donald Trump's employ, with photographic evidence, with videotape from Mar-a-Lago. The government's case here is airtight, and I would note that they are really successful in winning these types of cases up to 95% of the time.
More than 90.
Right.
The federal government is deadly efficient.